Everybody, welcome to tonight's webinar. We're super excited about having Amanda Winalda from Anderson Advisors. She's an attorney with Anderson. Super excited. The topic tonight, land trust, a powerful tool for real estate investors, as we discussed in the intro a little bit. Not just real estate investors, but really for everyone. There's something to learn here. I love you're covering personal residence trusts and land trusts. There are some nuances to that, and a trust is not just a trust. So kind of fun to have Amanda. Thank you so much. Before we get started, just want to quickly mention everybody who's on, generally we try to record these and put them in our YouTube channel. So expect in the next 24 to 48 hours that will be available to you. You can see we do a lot of different topics. I've had a lot of different instructors on all different topics, typically ranging from, real estate investing, asset protection, tax reduction, estate planning, all over the place. We've had even, like we mentioned before, even Kevin O'Leary from Shark Tank on here. Amanda's going to be even better tonight. I'm super excited about it. Better topic, more in depth. That's what we like. So excited about it. If you want to find out more, always suggest check out youtube.com, then channel Protect Wealth Academy, or just go to youtube.com, type in Protect Wealth Academy. You can subscribe. It's always nice to subscribe because then you'll get notices about when we do post new videos, but always suggest that you do jump on and click the little notification thing. My kids do this all the time, drives me nuts, a little ding of the bell when something new comes up. So if you want to be notified when something new is posted, subscribe and hit the notification to get notices about new videos coming out, at least a couple times a month. And also just want to mention a quick intro to our 3-day asset protection summit. A lot of you have been to our summit and seen, Clint Coons with Anderson Advisors. We love Clint. He's an amazing instructor. Mike Koval teaches a little bit about the stock market. And it's kind of fun with Mike because a lot of you are wondering what's happening right now in the markets. If you want to know, Mike's your guy. It's kind of fun. Mike and Stacy right there. Of course, everyone, Don's in the background here tonight. Don is the guru as well, asset protection. My favorite part, and everybody seems to love the case studies in depth on how to put everything together at our summits. You have Scott Estel, who's he was formerly at the IRS as well, Amanda. So pretty good guy there. Dr. Danko, the millionaire next door, and several more experts there. But we have a few dates coming up. Suggest you register. We have those on live stream. So they're live, but they're not recorded. We do that because of copyright issues, but we love live stream. That means you can sit at home, you can sit in your office, you can watch our 3-day asset protection summit from anywhere. And don't even have to get dressed. Come on down. Okay. Well, I don't know. Maybe it's depends on your office. Please do maybe. But March 13th through 15th, April 24th through 26th. Beautiful. It's a really good class. We highly recommend it. We're biased, of course, but check out our reviews. We know it's good. It's a good workshop. We'd love to have you. Always do a quick disclaimer, of course. Maybe you'll have one of these, Amanda, as well, but a legal disclaimer, of course, and tax disclaimer, investment disclaimer, whatever you want to call it, but this is not specific legal, technical, and financial tax advice for you. If you want specific advice, seek out a competent professional like Amanda at Anderson Advisors. And Amanda, you kind of introduced yourself a little bit. We'll let you maybe do a little more of that, but land trusts, super excited about this topic tonight. Thank you so much for being on. Go ahead and take control if you want and share a screen. I think that should be enabled for you. And then you just want to maybe take a few questions throughout and have a time for Q&A at the end, correct?
Right. So I've just got a few slides. We're going to go over some of the basics. I'll actually even switch over to this next slide here for our agenda. Had to come up with 3 exciting bullet points to grab everyone's attention on this super fun topic. So we're going to talk about the secret language of land trusts, why you need them, why every real estate investor should really have one. We've got a couple of different options for our land trust. So whether you're working with rental property, whether you're working with your personal residence, we've got, I'm going to go over the differences of what you need to look for there. And then your property's in a land trust. So now what? What do we do next? There's a lot of other steps that you need to do to make sure that you do have full anonymity there. My name's Amanda Winalda. I'm an attorney with Anderson Advisors. I started out here on the tax and professional advising side and then moved over to land trust a few years ago. The department had just gotten, when I started at Anderson, I didn't even realize land trust and deeds was a separate department. It was sort of just a service item that we offered, including land LLCs, corporations, things like that. But they've become so popular in recent years that our department's expanded 3 times for what it was. So I'm pretty much talked to any client who's had an issue with land trust, any structure that we've put together that involves the land trust. I get consulted on that over here. All right. Anderson, for those of you who don't know, Clint Coons, Toby Mathis, Michael Bowman are our 3 founding partners. We focus on tax and asset protection. So for those of you who have a CPA and have an attorney, if you're tired of talking to one and having to translate what one is saying into the language of the other, when you don't really even speak either language, that's where Anderson comes in. We have professionals in both sides under one roof or under one global roof as people have started to work from home. But it's part of the reason why I still come into the office. I can just bang on this wall right here, and Elliot Thomas, who's one of our tax professionals, can answer whatever question I need on that side. All right, so the secret language of land trust and why this should be part of every real estate investor's plan. First, let's just go over the basics. So a land trust has 3 parties, and a land trust, and I say land trust, that's more of a branding term or a marketing term. We're really talking about a revocable grantor trust. Revocable means that the person who puts it into the trust can take it out at any time. Your living trust is a revocable grantor trust. There's only 2 states that statutorily recognize what's called a land trust, and that's going to be Illinois and Florida. Florida is a special case because the land trusts there, the way that the statute is written, actually come with some built-in asset protection. So if you're looking to use a land trust, you've got your property in Florida, we're going to do something slightly different than if you're using a land trust and your property's in California. So a trust, the land trust we use, because we do at Anderson a few different types of trusts. We do Nevada Asset Protection Trust, we do living trust, we do personal property trusts. Each of those things are used for different things. So I'm generally talking about, when I say land trust, I'm talking about a revocable grantor trust that is specifically designed to hold real property, either rental or your primary residence. The 3 parties in a land trust are the grantor, the trustee, and the beneficiary. All right. So the grantor is, I did this fancy PowerPoint where different things fly on at different times. I'm actually very proud of myself. I'm old enough that we didn't learn how to use PowerPoint in school like the kids do. But the grantor is going to be the current owner. So that may be you, that may be an LLC that you own, that may be your living trust, but that's going to be the grantor. They put the property into the trust. They also retain the power to revoke the trust. So they can essentially cancel it, pull the property out at any time. So never fear, putting your property into a land trust is not a set in stone situation. In fact, there's a lot of times when you would be actually pulling your property back out of that land trust, and we'll go over those as well. The grantor is also the party that's looking for protection. Most of the time, if you have a lot of real estate in your name, you don't want all of that to show up in your name. So you're putting it into the land trust to get some of that anonymity there. Christopher, I am not going to be able to rattle off the Florida statute code for land trust. A quick Google search, you could search Florida statutes, land trust, it'll pop right up for you. No problem there, but I am not an encyclopedia in that sense. All right. So then once the grantor puts the property into a trust, then ownership splits between the trustee and the beneficiary. The trustee is who holds legal title. They're a fiduciary, meaning that they have to hold themselves to a higher standard that you can actually sue upon if they're not fulfilling their fiduciary duties. So in that sense. So another example of what a fiduciary would be is the investor who's investing for your pension plan or for your company's 401k plan. Those are fiduciaries. They have actual legal liability to properly invest the assets of the trust. They don't have any liability to the outside world, though, only to the beneficiary. So if your property's in a trust and the trust is sued, the trustee will be named in the lawsuit, but they're only there representing the trust, representing the property. They would not have any liability for the slip and fall. They would have no liability for the dog bite, for whatever it is that is actually the injury or whatnot for the trust. The trustee is also not anonymous. The name of the trustee becomes part of the trust. So if I'm your trustee and your trust is the 123 Main Street Trust, then what shows up on the deed, what shows up on the assessor's website, what shows up on the public record is going to be Amanda Winalda, trustee of the 123 Main Street Trust. So choosing that trustee becomes a very important part of your land trust. We've got one question. Can multiple grantors put their independent assets into the same trust? With land trust, you're going to find that a lot of the answers are going to be, yes, you can, but it's probably not a good idea to do that. So in terms of using a single land trust for multiple investments, that's not something that we would generally recommend. The whole idea is to separate out the liability so that the liability of one investment is not commingling with another. So you would want to put separate investments into separate land trusts. Whether or not those investments ultimately flow up to the same legal entity is another question. All right. So the trustee holds legal title. The beneficiary is going to hold equitable title. That means that all liability runs to the beneficiary. That's a legal sort of jargon, meaning that if the trust is sued for anything that happens with the property within the trust, then the beneficiary is going to be liable. However, they are anonymous in that they're not showing up on the deed. The trust agreement itself is not filed anywhere. So it's sort of your private paperwork in your filing cabinet. So nobody really knows who the beneficiary is. The way that we set up our initial trust is that the grantor and the beneficiary are going to be the same party. So if I'm putting my property into a trust, I'm the grantor, I'm the initial beneficiary. Then you're going to want to assign the beneficial interest to a legal entity for the asset protection. So here, if you can tell, this pink box changed. You're going to want to use a trustee LLC or what we call a nominee trustee. So Anderson offers nominee trustee services, meaning that one of our attorneys will sign on behalf of the trust when it is initially started and when you go to file the deed, so that their name shows up as a trustee on the public record. Our founding partner, Clint Coons, did that for a lot of years. His son, Carter, now works at Anderson, so he's sort of taken over that position as a nominee trustee. And so when we prepare the deed, moving the property into your trust, it's going to say Carter Coons, trustee of the 123 Main Street Trust. That's what gives you the anonymity. An alternative to that is using a trustee LLC, which is basically a placeholder. It's a generic LLC. We set it up in Wyoming because it doesn't show who owns that LLC. And then you're the manager, so you get to sign on behalf of that. And then when we assign the beneficial interest, this beneficiary, you'll be able to see here in the orange box, changes to a rental LLC or a LLC organized in the state where the property is located, specifically to be the beneficiary of that land trust. I am trying to check out some of the questions as we go. There are a lot. Martin is asking, can a land trust be used to hold properties within a checkbook controlled self-directed Roth IRA? So yes, any party can be the grantor. So if the property is already owned by the self-directed IRA, then yes, it can be put into a land trust the same way that a property already owned by an IRA can be put into an LLC. You're just creating one more layer in between the IRA and the LLC. You're creating that one more layer with the land trust there. Let's see. Does Anderson serve as trustee similar to how you do with holding companies? Yes, Jerry. I think I just answered that. We do offer nominee trustee services there. So I'll keep looking back at the Q&A, but there will be a section at the end for question and answer, because I know this is one of those areas where people have a lot of very specific questions. So just to reiterate, when we would use a land trust. So here at Anderson specifically, we have 3 reasons why we use a land trust. One is for privacy. We have clients who specifically, I have a client who is a doctor. She works in pain management, and oftentimes she has to tell her patients, no, you actually do not get any more pain drugs. And that is not a comfortable conversation to have. And that's not always something that they want to hear. So she doesn't want her home or where she lives on the public record or easily searchable for privacy reasons. So we shield your ownership of your property there. It also shields the existence of that LLC. So the property is going from your name to the trust. The assignments to the LLC never really see the light of day. You're not recording the trust. You're not recording the assignments. You're not giving those assignments to the bank. You're not giving them to a third-party lender. You're not really showing them to anyone. The only time you would is in the event that you needed to show that, no, it's not me that's liable for this lawsuit. It's this beneficiary LLC that sort of holds any of the danger and any liability into that one LLC. Only the assets in that LLC are available to pay that debt, and the rest of your assets are still safe. So it shields the existence of your property LLC. It can also avoid tax. So when we're setting up a structure, or when we're deciding, can we deed these properties directly into LLCs? Do we need to use a land trust? One of the main things we're looking at is transfer tax. A lot of states will charge what's called a dock stamp fee or a deed fee. That's often based on the fair market value of the property, how much the actual consideration of the property. For any of you who've purchased a property, that's just combined in the closing costs, sometimes based on the value of the mortgage. So Florida is another great example. If a property is free and clear, then we don't need to use a land trust to move it into an asset protection structure, because the dock stamp fee in Florida is based on the value of the mortgage. No mortgage, no transfer tax. In other places, there will always be a fee. And we want to make sure that the property is not reassessed because of a change in ownership or something like that. So we use the land trust to avoid it appearing like there's a change in ownership. The third reason is to avoid the due on sale clause. This is sort of a dreaded clause that when moving properties to an asset protection structure, everyone was worried that the due on sale clause in their mortgage would get called. That's the clause that allows the lender to call the mortgage due in full. And it usually applies when there is a sale. You sell the property, obviously your lender wants to get their money. But this can be triggered when moving to an entity. This isn't as much of a concern because back in 2016, Freddie and Fannie came out with guidelines that said that the due on sale clause would not be triggered if ownership is substantially similar. And they have published guidelines on that. That's about 90% of loans are backed by Freddie and Fannie. There's always that 10% where, yes, we are worried about the due on sale clause. So we're going to actually use the land trust. Another situation would be as, say you have a VA loan. You don't want to signify to the lender that you're actually converting it into a rental property. So you put it into a revocable grantor trust. From the outside, it appears to be a living trust. All states allow for living trusts. All states encourage transfers of property to living trusts because it cuts down on court costs and the need to put those assets through probate. So that is how our revocable grantor land trusts avoid the transfer tax, avoid the due on sale clause. All right. So one of the big questions that I've seen pop up in the Q&A is, who should be my trustee? The trustee shows up on the public record. The trustee has the ability to sign contracts on behalf of your land trust, enter into property management, lease agreements, etc. And you also want it to provide you with anonymity. So these are the 3 main options that we offer. And it's really one of the things that you need to understand before you set up your land trust, because once you've put the property into it, it's really hard to change it or undo it if you were looking for anonymity and you named your brother as the trustee. So the best and most flexible option is going to be a Wyoming Trustee LLC. I mentioned these before. This is a Wyoming entity. It keeps your name off the public record because Wyoming doesn't publish manager or member information. So it'll have a single member so that it's disregarded. It'll have one or two managers. If you have a spouse and you will both want to be able to sign on behalf of the trustee LLC, you can have multiple managers, not just one. It's the most flexible because you control that entity. So anytime you need to sign something, you're just signing it. You're not waiting for somebody else. This entity is a mere placeholder. We are not automatically pulling an EIN for this entity. It does not need a bank account, any of those things. There are a limited number of circumstances where you might end up needing one, but that is sort of done on a case-by-case basis. We can easily pull an EIN and you can open a bank account if necessary. The nominee trustee, so that's an Anderson attorney, Clint or Carter Coons typically. This still gives you anonymity because it's their name that's showing up on the deed. It's their name showing up on the public record, but it's slightly less flexible. Just because if you need something done, it's going to depend on their ability to get the document you need signed and back to you versus just getting the document, signing it yourself on behalf of the trustee LLC. You're maybe waiting for them to come back from a conference, or you're waiting for the notary to be in the office in Tacoma where they both work out of. I know there was a period at the end of December last year where there were ice storms. I don't know if you guys saw those videos on TikTok or Instagram of the Seattle area and people in cars just sliding down the street. Obviously, they weren't in the office during those days. So not in the office, they're not signing anything. They're not notarizing anything for you. So it's slightly less flexible. They stay on title until the deed records, and then they resign as the trustee. Per the trust documents, that just requires a letter. I, Carter Coons, resign as trustee of the 123 Main Street Trust effective on this day. Automatically, the successor trustee steps into their shoes. At that point, that's you. You're the successor trustee. You then move forward, signing documents on behalf, entering into lease agreements, property management agreements, but we don't change the actual deed yet. Normally, when a trustee removes themselves, you could file a trustee's deed to show who the new trustee is. We provide you with that signed deed, but you keep it in your file cabinet. You keep it as like a pocket deed, keep it in your pocket. You don't file it until you absolutely need to. That's going to happen when you want to sell the property. You need to sign the closing documents. If you need to pull the property out of the trust to refinance it or obtain a HELOC, you file that trustee's deed, and then you have the power to sign on behalf when dealing with third parties. The least expensive option is to use a trusted individual. This is the least anonymous. I like to say Google knows who you sat next to in third grade. Like you just Google your name and you're just astonished at what comes up. So at the very least, you want to make it somebody who perhaps doesn't have the same last name as you. They're still technically a fiduciary, but a layperson may not understand fully understand the implication of that. You don't have to worry about them stealing your property. You can always sue them for that, but I don't know, you could get in a fight with your brother-in-law at any point, and maybe you just don't want to have them on title. They will also, if the idea is to keep you anonymous, they're staying on the public record. They're staying on the deed. If that property is ever sued, like I said, they would be named in the lawsuit. They would simply go in and say, I'm no longer the trustee of this trust per this resignation letter dated however many months or years ago. But it's kind of a pain and not really something you want to ask your mother to do or your brother to do on your behalf. So a lot of times it's more trouble than it's worth. We offer nominee trustee services for $250. It's a one-time fee because we're only really doing one set of documents for you. And it's just well worth the money. For my own land trust and my own rental property, hence my trustee LLC. So it also gives you a little anonymity because somebody can search Clint Coons trustee and literally hundreds and hundreds and hundreds of properties are going to pop up. Anyone who understands what a trustee is going to know that it's not actually Clint's property and your name's not going to be anywhere on the documents whatsoever. All right, let's see if we could do a couple of so John W is asking, can I set a Wyoming LLC if I don't live in Wyoming? Yes, of course, you can live anywhere in the country and set up an LLC anywhere in the country. Because this trustee LLC isn't really doing any active business anywhere, it's just a placeholder, you can set it up from anywhere. Robert's asking, the Wyoming title method seems somewhat loose in the event of the death of a trust member, as the lack of recording seems to require the physical possession of a copy of the trust in order to transfer title fully to the surviving member of the trust. So a couple of key things with the land trust is that it's not an estate planning tool. So a land trust is not going to have any heirs listed. It's not going to have any succession provisions in it. The successor trustee is going to be you. It's not going to be some other like your children or your sister who going to take care of your children. It's not an estate planning tool. Really, once you put the trust in place, you do need to fund that into your living trust, whether that's through your structure or making the beneficiary directly your living trust. And then any provision for succession at time of death would be provided for in your living trust, along with all of your other assets. So we're not really talking about estate planning, we're talking about asset protection planning. If Gina's asking if you have a mortgage on that property, doesn't that violate your anonymity? So with the land trust, we are changing the current owner on title. So that's what's going to show up in the deed records. That's what's going to show up in the assessor's website. Any existing documents in the chain of title are not going to change. So you'll show up as the previous owner. If you've got a mortgage on the property, that is still going to be there. It does take a little bit more savviness to look back on the records. What we're looking for is that when somebody's doing a general asset search on you, your name's not popping up. If they know, if you rear end someone, they take down your name and your info. They go to an attorney to say, this person was driving a nice car. My neck hurts suddenly. Let's do an asset search. If nothing's really showing up in your name, sure, you may have a mortgage, but that could have just been a stale mortgage where they haven't filed the release yet, right? Then if nothing's really showing up in your name, then that attorney is thinking, well, I don't know if the juice is worth the squeeze on this lawsuit. Personal injury attorneys work on contingency. That means they only get paid if they win the case. They only get paid if they settle the case. So they're only taking cases that they think they can win or that they think they can settle if there's deep pockets at the end there. So anonymity in terms of asset protection is not a bulletproof plan. That's what your LLC and your structure is for. Anonymity is to provide a smokescreen to make it a little harder to figure out who actually owns this property, a little hard to figure out what you as an individual own. Okay, if the public records show the same Wyoming trustee does not allow someone to figure out that all those land trusts are connected, you could potentially make the inferential leap that that's what it is. But I mean, Clint serves as nominee trustee for, like I said, hundreds of land trusts. I would not, and seeing that, personally assume that that's connected, especially if it's an LLC, if it's a business entity. My first assumption would be that that is a third-party trustee who serves as trustee for many, many, many clients, like a bank would, or any other third-party corporate trustee. All right. Okay, let's just keep going for time's sake. So our next topic is land trust for your homestead versus your investment property. So first, what's a homestead? So a homestead is your owner-occupied residence. It's where you live. It's where you own your home with the intention to stay. In some states, they even classify a homestead. You don't even have to have an ownership component. It just is where you live as your primary residence. But if you do own the home, it offers certain legal protections. So a lot of it's going to be based around creditor protections and asset protection webinar. Creditor protection is a big thing. There's also federal and state bankruptcy protection built into your homestead that allows you to exempt a certain amount from bankruptcy. In a Chapter 7, it will keep you from losing your home completely. The idea being that even if you're a debtor, we don't want people homeless and out on the streets. In a Chapter 13, that's going to reduce your payment. Chapter 13 is a payment plan. Chapter 7, sort of, you lose everything except your homestead. The homestead exemption can double if you are a married couple. So you often get whatever amount for one spouse, you'll get double for the second. And you will often run to any surviving spouse or children. One example is, you'll probably know, Florida, Texas, very famous for offering 100% protection of your homestead. States will limit the acreage often, or limit it to one structure on a certain amount of acres. Typically, if it's within a city limits, it'll be a smaller acreage versus a rural area will be a larger acreage. California famously protects very little, although that changed a couple years ago. It bumped up to 600,000, depending on the average home value in whatever county your property's in. So it does vary quite a bit across the United States. Generally, you can say that the red states tend to protect more of your homestead and the blue states tend to protect less. The tax breaks are typically for elderly, disabled, veterans. Some states offer tax breaks for first responders. You do have to apply for these homestead protections. You have to show that you have served in the military, you have to show that you're disabled to a certain extent. Every state and county will have different documents that you have to complete. Once you put your property into a land trust, you're going to have to reapply for all of this. You're also going to have to make sure that the trust complies with the statutory requirements for these tax breaks. The tax breaks come in two types. It either freezes the value so that your property tax is not increased or only increases a certain percentage. So I live in Clark County, Nevada. Our homestead cannot increase in property tax assessment more than 3% a year, which is much less than it would have increased given the way that the market has shot up around here. The other way is by reducing the actual taxable value. So if your home is worth $200,000, it'll say that the assessed value cannot exceed X number of dollars. So then you're only paying tax on maybe 150 of that 200 instead of the full 200. And again, if you are the elderly, disabled veteran who qualifies for the tax break, if you pass away, often your surviving spouse or even your children who stay in the home can still qualify for that homestead protection. Okay, so we do two separate types of trusts for the homestead versus a rental property. And here are the key similarities and differences. The main similarity is that it's structured essentially the same. There's going to be a grantor, there's going to be a trustee, and there's going to be a beneficiary. The difference is that if it's a rental property, you're assigning that beneficial interest over to an asset protection structure. So you're looking at an LLC in the state where the property is located, typically. If it's a personal residence, then you're assigning that beneficial interest into your living trust. So like I said, land trusts are not estate planning tools. You still need to link it up with your estate plan, with your living trust, if you want to avoid probate. The difference is that the homestead, or the personal residence trust, as we call it, will have specific language in it to preserve that homestead right. So we've done the research in all 50 states. Can I qualify for my homestead exemption if my property is in a trust? Some counties have even come back to us and said, this is the specific language that we need to see verbatim. We incorporate that when necessary, but the general term that needs to be seen is that the beneficiary has the right to reside in the property for their lifetime. That's the way that they know that it's your homestead. You must reapply for the exemption once it's put into the trust. Changing your property ownership to the trust is changing the ownership. So no longer is it you applying for the homestead exemption, it's your trust applying on your behalf. All right, let's see if we have any. For rental, if assigned to an LLC, then the LLC is assigned to the living trust. Yes, correct, Gina. And I don't know if you have good timing, but your question is just popping up right when I'm about to answer. Okay. Delroy's asking, what prevents someone from hijacking a property title? We've seen stories of people who have been evicted from paid for properties that were sold without their knowledge or permission. This is actually something my parents have asked me about. I think it's kind of one of those stories that targets older people who may not understand. I mean, if we like to say we record a lot of deeds here at Anderson. The recorder's office will record a photocopy of your butt if you turn it in on the right size paper with the right size margins and it's notarized. Like, the recording office does not check to make sure that the person on the deed owned the property before. They do not check to make sure that anything is spelled right. You could deed your property to Mickey Mouse and they will record that deed. It's the assessor's office that is checking all of that. So when we transfer property into a trust and we get a notice saying, hey, we think that the ownership on this property has changed and we're going to reassess this property, it's not the recording office that's doing that, it's the tax assessor's office. And so they're the one who we're working with to say, no, look at these trust documents, the grantor, the beneficiary are the same. We appeal those processes for our clients that we're filing deeds for. In that sense, anybody could file a deed for anything. Worst case scenario, you're having to go to court to do what's called a quiet title action, where you bring in all of your documents showing you purchased the property, you never sold it to this party, and that party brings in essentially nothing because they have nothing because they never purchased the property at all. So worst case scenario, you're doing a quiet title action, but for the most part, this is going to be very, very, very rare, any type of hijacking of a property, and that would have the same percentage chance of happening whether you held the property in your name, in a land trust, in an LLC. It's not really something that I would worry about. Okay. How would a single member LLC holding 10 rentals already fit into a land trust in Texas? So Texas famously does not have any transfer tax. They do have very, very high property taxes. It's sort of the backdoor way that Texas gets its taxes when they don't charge any income tax. So anyone who's been moving there, fleeing the Western blue states so they don't have to pay income tax, well, surprise, you're paying very high property taxes. A single member LLC holding 10 rentals would most likely want to split those rentals up. So if you're keeping that LLC, it's the grantor, it's putting each property into a separate land trust. Those trusts would go to separate LLCs. In Texas, you could potentially use a series LLC. It's recognized there, and then that would flow into your asset protection structure. We have this huge spreadsheet that breaks down every state, whether you can go from an individual to a trust, an individual to an LLC to a trust, a parent to a child, a living trust to a land trust, any possible option. We've done that research. We've pulled those exemption codes. And so whatever way you currently hold your property, we can figure out a way to either use land trust to avoid transfer tax or put the property directly into the LLC if you need to. All right, next section, our next and last section, and then we will focus a lot on Q&A. So my property's in a trust. Now what? This is sort of the big thing. You're so excited about starting your asset protection structure. You're so excited about getting anonymity, and then everything's signed. Your I's are dotted, your T's are crossed, your deeds are recorded. And then you're like, wait a second, my name's not on this property anymore. What do I do next? So there's actually quite a few steps you need to take. First, you're going to sign your trust documents, the trust agreement, the certification of trust. The certification is basically a summary of your trust. It's what you can give to any third party when you need to open a bank account for your trust. You give the bank the certification of trust, keeps you from having to lug around the larger trust document. Every state has a statute saying that third party can accept the existence of the trust through the certification. They don't need to see the full trust agreement. That said, sometimes you are going to have to show the full trust agreement just to get the thing that you need. For example, you need a bank account. The bank won't open the account without the full agreement. You're giving them the full agreement. They have what you need. You're going to need that. But you sign your trust documents, you transfer the property into the trust. This is done via a deed that's recorded. One state, Pennsylvania, we don't actually record the deed. Pennsylvania has just been very hard to work with. A lot of states ask for trust documents to just confirm that there's no change in ownership. California asks for them all the time. It takes a little bit longer for the deed to record, but it's not an out of the ordinary step. There's just a couple of states that just don't like anything that's not a very strict living trust. Pennsylvania is one of those. So we actually transfer the property. A deed is valid once it's executed. So we have you sign the deed, keep it in your pocket as a pocket deed. You don't actually record it until it's necessary, because Pennsylvania, even using a land trust, you can't avoid transfer taxes over there. So once you transfer your property to the trust, you execute the assignments of beneficial interest. So that's either moving your property to your living trust, if it's your primary residence, or to a rental LLC, if it's a rental property. And then if any nominee trustee that you're using would resign. So if it's Clint or Carter, one of our attorneys, we would prepare resignation paperwork, resignation letter, resignation deed, send that to you. If it's a friend or family member, we would provide resignation paperwork for them to resign as well. It really is just a simple letter. However, if it's a Wyoming Trustee LLC, you don't actually have to have the Wyoming Trustee LLC resign. You can just keep it on indefinitely. But then the other two key things are updating your property insurance and updating existing contracts. So anywhere where you were previously signing as a homeowner or the landlord, you need to replace that with the land trust. The way that you would sign it is the name of the trustee on behalf of the land trust. So with your trust, it can get a little complicated. If you're signing on behalf of your Wyoming Trustee LLC, I sign Amanda Winalda, manager of Trustee LLC, as trustee of the 123 Main Street Trust. So we have a lot of resources, a lot of examples that you can look up where it makes it very easy for you to figure this out. I know it sounds complicated now, but it is very easy once you sort of get your documents. You can see how it works. You can just use the signature blocks in your documents for signing things. Updating your property insurance. I have come across a few snags. Florida, for example, California, you could tell we work a lot in certain states. We've had clients who haven't been able to update their property insurance. So the general default is that the land trust is the primary insured, and your living trust, your rental LLC can be the secondary insured. If you're using a third-party property management company, they will often require to be on the insurance as well. So you're adding them as well. California, because of the wildfires, Florida, because of the hurricanes, insurance companies have stopped issuing new policies in some areas. In those cases, you would continue with the insurance that you have. You would add the land trust as a secondary insured, you being the primary insured. Obviously, having insurance is better than having no insurance. So if switching the policy up would cause it to be unavailable to you, you definitely don't want to do that. Overall, you just want to work with your insurance broker to make sure that you have the coverage that you need. So give them scenarios. Hey, if this happened, who would the check be made out to? Which parties are covered? Just work with them, ask a lot of questions, make sure that you have the coverage they need. Every policy is written slightly different, so it's hard to give sort of a general rule on that. Wendy, I think that answered your question on would there be any problem getting insurance in the trust name? We do have a recommended vendor, National Real Estate Insurance Group. They work with land trusts all the time. I use them for my land trust. It wasn't an issue moving it over. If you are working with an insurance broker not in Illinois or Florida, you don't want to refer to this trust as a land trust because they're not statutorily created. Just refer to it as a revocable grantor trust. If you say the word land trust to anyone outside of Florida and Illinois, they sort of go, oh, we don't do those. We don't. Nope. And they just back away in a very nervous manner. But every state you can insure a property that is in a living trust, and a revocable grantor trust set up only to hold real estate is legally equivalent to a living trust. So you shouldn't have a problem setting it up. Yeah, yeah, Wendy, California is a pain. That's why we left. Updating existing contracts. So you'll want to update your lease agreements. If the lease was between Amanda Winalda and the tenant, I'm no longer the landlord, my land trust did. So now the lease needs to be between Trustee LLC as trustee of the 123 Main Street Land Trust. In that sense, if you have a property manager, they should have forms to assign the existing contract over to you. If not, we have forms on our portal that you can use to assign any existing contract. And then when you have tenant turnover, then that's when you would sign the new lease with the new land trust. Property management agreements as well. Property management companies, good ones, will have no problem with that. You just say, hey, I put my property in a trust. They'll want to update that agreement with the name of your trustee as well, just to protect themselves. All righty. That was a mouthful, everyone. Okay, I'm opening it up for questions. I'm going to just start going through these. We're going all the way. If you can hear my mouse roller, we're going all the way to the top, people.
Bring it on, Amanda. Thank you so much. I love it. I think Don and I will jump in and answer some questions. Go ahead and jump in. If you want to go ahead, wherever you left off, feel free to jump in.
I was just going to jump back to the top.
Okay.
But yeah, if you guys want to pick some out, I'm a little tired of hearing my own voice, so having you bounce off a little.
We're not tired at all. So let's answer the questions that we can. Amanda, are you okay if we go till the top of the hour, and then after that we're just going to have to refer people if they wanted a consult. Before we do that though, and their questions are specific to them, not something that we can do with 300 or 400 people on the call. If it's specific to them, we want to offer a consult. If they wanted to meet with somebody from Anderson, how would they do that?
Yeah, we've got a link. Kendall's got that link. You can put it up into the chat. Did you get it?
It's in there. It's in the chat.
Okay.
Yeah. So it's actually clickable, everybody. So if you want to click on that link there, aba.link protect 0221, kind of hard. Click that link, take you right there. And what do they do there, Amanda? It's just a consult with somebody at Anderson who can help you with land trust, right?
Yeah, we have a few dozen attorneys and business advisors that all day, every day, they structure people. Basically, get a good feel for what assets you have, whether that's retirement accounts, rental properties, whatever, what your goals are. And then they build a blueprint structure for you. Anytime they all know land trust, because I am doing a lot of intercompany teaching all the time. Anytime a new thing pops up, we're really good about that. If you have a sort of unique situation or a little bit crazy situation, or a situation where we just kind of sigh and say, man, we wish this person talked to us before they started doing this, then they can consult with me. I do that all day, every day for the higher level questions. Most of the time it's pretty simple, but yeah, it's 45-minute free consult with all of our professionals.
And they'll schedule that right there, and they'll get a hold of you guys pretty quick. Anderson, we've done a lot of consults. They're fantastic. And, be patient. There's a lot of people on the call, so expect their call queue will probably fill up pretty fast, as always. So just be patient. Probably next couple of days, even in the next week, they'll probably get back to you.
Mm-hmm. Definitely.
Okay. So Stephen's asking, what's the best way to build a land trust to create and build a family legacy through this type of real estate investing?
Sure. So Stephen, land trust is just one piece of your asset protection puzzle. It has its uses. And then ultimately, everything's going to funnel down to your estate plan. So if you're looking at building a legacy, making sure that you're able to transfer those assets and that wealth to the next generation, the key is not going to necessarily be your land trust. It's going to be your living trust, your estate plan, and that asset protection structure so that you're not losing all of it in one fell swoop. I mean, Clint has so many stories that just crush me about couples that worked to put their kids through college. Their kid goes off to Arizona State, gets in a car accident, and their 10 properties that were all in their name, their nest egg, their retirement, just gone. So the asset protection structure, of which the land trust is a part of, isn't designed to never get you sued. It's designed that if something does happen, you're not losing everything in one fell swoop. So ultimately you protect it, and then to preserve it, to give it to the next generation is going to be in your estate plan.
Perfect. Lynette's asking, I'm in the process of creating 3 LLCs with Anderson. They're owned by my self-directed IRA. How do I fund the bank account? Does each land trust need its own bank account, or just one in the self-directed IRA? What do you suggest, Amanda?
So we generally say that each LLC is going to want to have its own bank account. When we're talking about LLC and asset protection, one of the keywords is the corporate veil. So when courts look at whether or not they want to allow a creditor to pierce the corporate veil to get at the assets of the owner of that LLC, they're looking at a balance of factors. It's what we call a balance test. So one of the factors is it being run like a true separate and distinct business? One of those things is having a separate bank account. So the general default rule is that each LLC would have a separate bank account. If those LLCs are owned by your self-directed IRA, then the bank account would still be in the name of the LLC. You would fund that bank account through your self-directed IRA. You do not want to be taking funds in your personal name and pushing it to those LLCs, because that's a prohibited transaction. So if you do have just one bank account, because you can imagine having a portfolio of 50, 100, 20,000 properties, do you really want a bank account for every LLC? At some point, it becomes unwieldy. In those cases, you can consolidate. You just want to make sure that your books and records are very, very clean. Each property has its own set of books, so that in the event that you needed to separate out the money that was in a single bank account, you could easily do so through your bookkeeping.
Perfect. Okay, Mark is asking, what's the difference between a COPE, ADAPT, and a land trust? And when would you use one over the others?
Sure. So a land trust isn't going to offer any asset protection. I actually don't know what a COPE is. Sometimes the alphabet soup gets hard to keep up with. But ADAPT is an asset protection trust. Those have built-in asset protection. So that's actually transferring to a completely different legal entity. They're typically not revocable. So you can't pull the property back out like a land trust, meaning that the beneficiary still has legal liability, the grantor beneficiary. There's also, for asset protection trusts, there's statutorily created timelines. So if you put all your assets into a trust, typically a creditor can still force you to pull them out if it's within a specific time frame. Sometimes it's 2 years. It sort of just depends. And so it really has to be something that is set up before you get sued if it's going to protect you at all. We do some Nevada asset protection trusts. There's not a lot of situations where you would go for the Nevada asset protection trust instead of just going with a traditional land trust plus LLC plus holding company structure, because it's a lot less flexible. You can't get your property out the same way that you could in a land trust.
Okay. Debbie, complicated situation. And this might be a really good one for a consult.
Hey,
Let's
Don, I'll jump on one. We got several questions asking, what was the name of the insurance company you recommended?
National Real Estate Insurance Group, NRIG.
National Real Estate Insurance Group. Okay, I'll put that here in the Q&A.
Yeah, they're a big one. Every conference that I've been to for Anderson, they've had a booth there. So if you're in that space, they'll come.
Okay,
up.
Thank you.
And that's asking, what's the difference between a land trust and a revocable living trust? Both of them are revocable grantor trusts. So they're similar, but the land trust really is specific to a piece of real estate. Is
Exactly.
that fair?
Yeah, that's exactly true.
And the revocable living trust is like your great big popcorn Tupperware bowls. You never put your Tupperware bowl in the cabinet empty. You always put all the little Tupperware bowls inside of it. You have a house, you put it in there. You have an interest in an LLC, you put that in there. You put all of your interests in other things. Your life insurance might come into that. You might make your spouse as the the beneficiary and your trust as the contingent beneficiary, but
Mhm.
everything flows into this is your big estate plan where you're establishing your values. Here's what we do. Here's what we want. Here's the conditions, but that's very different than a land trust, but both of them work the same way. Am I?
Correct. No, that's exactly right. I like your Tupperware analogy. I use a Russian doll analogy that your land
There we
trust
go.
is like the smallest little doll, and then you put it into an LLC, and then you put it into a holding company, and then the largest doll is your estate plan. Estate plans are typically 40 to 80 pages and have all kinds of language on who your heirs are, what ages they get distributions. You don't want your 18-year-old kid to get 25 rental properties all at once. You want to slowly give it out. You maybe want to disinherit someone. You maybe want to give to charity. None of those types of provisions are going to be in a simple land trust. The land trust is 15 to 20 pages. It's designed to hold a single piece of property. You can put more than one property in it for asset protection reasons. You typically don't want to, but you're exactly right, Don. It's not designed for estate planning. It's designed to be a piece of an asset protection structure that ultimately the whole thing goes into your estate plan.
And you could use a land trust if it included beneficiary grant, but then it just complicates the whole. I mean, it's a trust. It could avoid probate if it had the right language, but that's not typical of what a land trust would do.
Right. And you can, especially for your primary residence, we're just making the beneficiary your living trust anyway. So it's just a little double step process there.
And Debbie's complicated question really has to do with transfer taxes in Texas, which you already answered. There are no transfer taxes in Texas. Is that right?
That's right. And transfers in all states between a parent to a child are exempt from transfer tax. So I could give a property to my child. They wouldn't have to pay any transfer tax. The property wouldn't necessarily be reassessed. The reason you may not want to do that is because lifetime transfers don't receive a step up in basis. So it's sort of better to leave your property to your kids when you die, so they get that step up in basis.
Okay. Stephen's asking, is this the way the most wealthy build assets through land trusts? A yes or no? And can I step in on that and say,
for sure.
No, it's just savvy real estate investors. I've known investors that have 500 or 600 properties that have never used a land trust. That's not what makes them wealthy. Well, the land trust is simply a tool. I've got a 4-foot pipe wrench in my garage. It's a wonderful tool when I need a 4-foot pipe wrench, but I don't use it for every property. I don't use it. Does it build my wealth? No, it's a tool to maybe mask, maybe to be able to transfer properties, maybe to avoid transfer taxes, but it's not a tool that you use. Amanda, would you use it for every property that you own? Would you use a land trust?
I definitely would not. A land trust situation, just because, and we had a lot of clients sort of coming up on this when interest rates were low and the news was interest rates are going to rise. Everyone was frantically trying to cash out refi or pull a HELOC from their property. A land trust is designed for anonymity. Your name is not associated with it anymore. If you are asking a bank for a lot of money, they want to see your name on that property. So if you're moving things around quickly, if you're burring, if you're wholesaling, even if you're picking up something quickly and needing to get rid of, doing a lot of turnover, a land trust isn't going to be the best tool for that. It's a set it and forget it strategy. If you know that your property's got a good, like we turned our primary into a rental, we got that nice 2.5% interest rate, we're going to keep it there for a decade. It's just going to be there. There's a couple of extra steps involved when you want to move the property. So it isn't for everything. It really depends on what your goals are and what type of investing you're doing.
Okay, talk to me about something else for a second. What if I want to sort of wholesale a property? buy it and really, I want to assign the mortgage. I don't want to reassign the mortgage. I want to, I want to sell the property, but really wholesale it. How do I use a land trust to do that? Is that a tool that's used by wholesalers?
Yeah, so you can wholesale with a land trust type trust. When you're wholesaling, you're getting property under contract and then you're assigning the contract to another party. In states where you can't assign contracts, you can get the property under contract by the trust, and then you could assign the trust to a new party. So the seller puts their name on the trust documents, and then when they're giving it to the person that they're wholesaling to, they're changing the beneficiary to that new person, they're changing the trustee to the new person. So they're not assigning the actual purchase and sale agreement, they're changing the entity that is a party to that person purchase and sale agreement. So you can wholesale with the land trust. We offer, like, it's a kit, it's more of a instead of having us like take the time to draft the whole thing, it's a much shorter form that you can copy and sort of do it quickly. Because, you know, you're wholesaling, you're knocking on doors, you're driving for dollars, you're sitting at people's kitchen tables. You're not then saying, hold on, let me call Anderson, and in 2 weeks we can put this down on paper. Like, you want to get their signature on something that day. So you need something that's a little bit more flexible. So in a wholesale situation, you're entering into the purchase sale agreement with the trust, and then you're assigning that trust by changing the beneficiary, removing yourself as the trustee to the new person who's actually going to close on the property.
Okay, perfect. Thank you very much. Because it's a marvelous tool for the right reason, but I don't use it under the sink or when I need a screwdriver, or it's a tool. Thank you for that. Okay, Debbie's
No more
asking.
pipe wrench, Don.
You love my pipe wrench?
I said no more pipe wrench. I want to knock out about 5 or 6 more questions real fast too. The recording will be available tomorrow, guys. So look for an email from Zoom. That will come tomorrow, probably tomorrow morning early. So it will not come from Protect Wealth Academy directly. It does come from Zoom as being part of this webinar. Anybody who registers will get that tomorrow morning.
Thank you. Okay. Debbie's asking, I can't see how a trust helps if it's revocable and not protected. The land trust is not asset protection, and it won't help you from protecting you from Medicaid. And in a lot of states, neither will a revocable living trust. It's not going to help you from inheritance taxes, or it's simply a tool for real estate investors. Amanda, add to that if you would.
Yeah, a lot of times people will want one single thing to do it all, and that's, like you said, you have a tool belt, and sure, you see the made for TV things that sell the tools that can do multiple things, but there isn't one tool that can do everything. The land trust is just that. It's to give you some privacy, to give you some anonymity, to make it just a little bit harder to take that target off of your back while you're walking around out there. It's going to offer asset protection when combined with a structure with an LLC, but on its own, it's not transferring property to your heirs. It's not giving you any type of liability protection. It's not protecting you from any of those other things, unfortunately.
Okay, great. Annette says, if you have one LLC and you want to have a land trust for each property, and only the individual properties in each trust, what would the cost of the trust be?
Sure. We offer individual land trusts. We also offer an unlimited package. So for an upfront lump sum, you can charge you can create as many land trusts with us as you want. All of those come to my team who drafts them. We sometimes wonder if it's worth it, because we get those clients who do like 20, 30 land trusts, but you click the link to get the 45-minute consult. Our advisors are really great about giving you options. They'll say, this 100% bulletproof structure is going to cost you this much. Here are the places where we can make modifications that are still going to give you what you need, but might be a little less expensive.
Great. Okay. California charges an $800 filing fee for corporations, LLCs, limited partnerships. How do you get around that with a foreign LLC? I know Clint's talked about Wyoming statutory trusts. He's talked about you're sitting in California thinking about your Tennessee property. Oh my gosh, you just constitute the act of doing business in California. How do you get around the $800 maintenance fee?
There's a right way and there's sort of a less right way. With the trustee LLC, the entity's not ever really doing any business. So you're not filing a tax return. You're not even really knowing about it. Most CPAs are still going to want to report it because when they complete that return, it's their license on the line if something's not right. So in that sense, you can consciously avoid it. I don't like recommending that, especially if you're in California. The solution that I would put for that is to use a nominee trustee. So it's a little less flexible in terms of if you need something signed, you got to wait for Carter or Clint to be available. Carter's young and still proving himself, so he has to be in the office every day, unlike Clint, who's taken up golf. So it's sometimes not in the office every day, which is why we're changing it up. That's $250 a one-time fee versus an $800 annual fee. It's pretty clear what your option is there. So you can use a statutory trust. I like to use those more in lieu of an LLC to hold property that's located in California, only because they're a little more expensive to maintain. It's created in Wyoming. It's also cross-registered or foreign filed in California. So you are paying 2 sets of filing fees, 2 sets of registered agent fees. It still comes out to be less than the $800 LLC fee, which if you've got dozens of properties, even that $250 you're saving is significant. But if you're in California, I would really go with the nominee trustee in those cases.
Can you get a loan for a property that's owned by a land trust?
It's hard. Like I said, a lender wants to see your name on the property. If you're looking for that traditional mortgage with the lower interest rate, you're most likely going to have to get the mortgage in your name, transfer the property to the land trust after the fact. You can work with maybe a commercial lender, somebody who's not looking at your personal credit to back the loan, but looking at maybe the rents from the properties themselves. It's possible. You do have to shop around though.
Okay. Michael's asking, what about the beneficiaries if they die? You always, I recommend at least annually you review your trust, and if the beneficiaries pass away, you have success, you have contingent beneficiaries, and you update your trust occasionally and look at it. And I don't know, your recommendations, Amanda?
Well, for a rental property, ideally you're assigning the beneficial interest to an LLC, and an LLC can't die. I mean, it can be dissolved, but it's not going to die on you. So in that sense, that's where the Russian doll, the Tupperware analogy comes in. The rental LLC will continue, and if you as the grantor have passed away, then your living trust kicks in. Whoever you've named as your successor trustee now has the power to control your entire structure, sell things, distribute things to your heirs. So you're not really worried about that.
Okay, Robert, so you use the land trust properties for succession. We really want to use both the land trust and the living trust, one of them funded by the property, correct?
Yes.
So the land is titled in the name of the land trust. The beneficiary would be either a LLC, if it's a rental property, it would be your living trust if it's a personal residence.
Mm-hmm.
And even if it were, let's say, a rental property, you would take the deed to the property, title it in the land trust, which is owned, then you're assigning the beneficial interest to the LLC, which ties into your trust with the succession plan. Mm-hmm. So even your ownership of the LLC, everything's going to dump into that big
Yep, everything's gonna fall under the control of your successor trustee. If you don't have an estate plan, get one. But if you don't have an estate plan, your heirs would have to probate your will or probate your estate. The court would name an executor or a personal representative, and then that person would take control of your entire structure, all of your properties, and distribute it to your heirs.
When Anderson sets up a land trust for a rental property, do they charge for the deed when it goes into the LLC?
Sometimes. So if you go to one of our tax and AP events, the base package includes the deed and the trust together. But typically, if you're purchasing services a la carte, the trust and the deed are separate. Thought about combining it, but we've just done it that way for so long. Not everyone, and enough clients only want the land trust and enough clients only want the deed. So we do it separate. Plus, we do a significant number of transfers directly into an LLC or to a land or to a living trust. So, but sometimes if you come to we offer packages that'll include it. It just varies. Honestly, our advisors are super great people. They want to make something work for you. So these are questions that you can ask. They'll come up with something that makes sense.
George is asking whose name will show up as a taxpayer for the property.
So the land trust shows up as the taxpayer. So we offer what's called a company assistance program that gives you essentially I don't want to say it's a virtual office because we technically do rent space to clients in our Las Vegas offices, but we list our address for the property tax statements and we forward those to you. We have a whole cloud box that we send them to you. My department also gets notified of any notices coming from the county so that we can handle those on your behalf. But the trust and itself would be considered the taxpayer. The address on the assessor's records would either be maybe a PO box or our company assistance address. But you can still just pay the property taxes directly from your LLC bank account. You don't have to create a bank account in the name of the trust just to pay the property taxes.
The tax assessor doesn't care who pays the property taxes.
Just like your mortgage lender, they don't care. They just want to know that it got paid.
You can pay my property taxes if you want to.
Mine too.
The county will take it. It doesn't matter. Okay, Christopher, are there yearly fees for a nominee trustee? No, because the nominee trustee resigned. As soon as the deed was filed, there's no annual fees for that.
Nope.
Okay, good. We're zipping a few. Amanda, let me zip ahead for a second.
Sure.
And that is, I've taught land trusts for 20 something years. And I can walk somebody through step by step exactly how to do things. And almost invariably, they screw it up. Because there's so many steps. I'm creating the trust. I'm doing with the nominee trustee who, after the deed is signed, was going to resign. Oftentimes, we're going to assign the beneficial interest to somebody after the deed is, and so it's the steps, and then contact the property or the insurance company, and there's so many steps. My recommendation has always been, let Anderson do the first. If you got 10 properties, let Anderson do the first one for you. Go through the steps, and if you want, after that, you've got a template at least. Unless you're using lots of other states, and then it's going to be different in every state. And I love the fact that you've got a department that just does land trust, personal residence trust, and the deeds that go along with it. I would never recommend using a Quicken Family Lawyer or LegalZoom or something to do a land trust, because I'm sorry at LegalZoom if you're listening, but there's too many steps and it's too complicated and it varies so much from state to state. Is that a fair? You're doing it. You're in the trenches. I'm not, but I see so many people screw these things up just because they don't do it right.
Yeah, that's 100% true. And I feel like I apologize to LegalZoom every time I'm on a webinar. But I mean, I created my first LLC through a similar company, and you go through an interview and you answer a bunch of questions and you don't understand what they're really asking you. Like, what's the grantor? I don't know. Who's the beneficiary? I think it's me. I mean, even with our land trust that we draft, we'll have clients come back and say, hey, you got the beneficiary wrong. It's supposed to be my LLC. Well, no, you're on title, you're the grantor, you're the initial beneficiary. These secondary set of documents will change the beneficiary to your LLC. So it is complicated. The good part about, or the great part about our department is that my team specifically trained to see anonymity issues, to notice if there's going to be a transfer tax issue, to see if there's going to be a change of ownership issue. And then those come to me to troubleshoot. And it's kind of a fun, like, game, solving a riddle and trying to make sure that we're getting what you need in your structure, using the land trust the way that we should. We've had clients just this week come to us to say, oh, my property is already in a land trust. Like, okay, show us the trust documents so that we can restate the trust. We can get it into your structure. Oh, I don't have a trust agreement. Well, how do you have a land trust if you never signed anything? Or clients who will sign their deed before they sign their trust. Well, you can't deed a property into a trust that doesn't exist yet. So there are so many ways to do it wrong that I would.
You're being so politically correct.
I know.
So nice.
Not just because that's my department that does the work, but I would much rather have someone come to us with a ton of questions about how to do it right the first way than come to us after the fact and have us try to undo what they already did wrong. It's much easier to just start off on the right foot.
Great. Okay, Maureen is asking, stating insurance companies will not change the insurance owner name into a trust if there's a mortgage, which I think she's right, but you could list an additionally insured, could you not? Is that how you do it?
Yeah.
Okay.
You just have to add, you really have to work with the company, just because different insurance companies have different underwriting policies and all of that. Just work with your broker to make sure you're getting the coverage you need.
Is Missouri difficult to work with?
Not necessarily. Like I said, the red states tend to be easier, more landlord friendly, easier to work with than, say, the blue states. And that's just a very general observation, I guess. No statistical data backing that up. Missouri's pretty easy. There's not any, off the top of my head, any specific issues I can think of that we've run into there.
The only difficulty I found in Missouri is they are the show me state and they want to see the documents. Darn it.
And a lot of times that's fine. Like
kidding.
California, that's fine. We'll show you the trust documents. The thing you have to really think about when turning over any documents for your trust is this third party going to publish this on the public record somewhere? The assessor's office, the assessor's office isn't taking your trust and recording it. They're just looking at your trust to make sure there isn't a change of ownership and that they're not going to hike up your property taxes. Then they shred it. They don't. A lot of times the letter asking for the documents will even specifically say, this is not for the public record. We're not recording it. We're just using these documents to verify information.
Okay. Is a Wyoming trustee LLC different than a Wyoming holding company LLC?
Yes and no. So they're set up exactly the same way. They're just for different purposes. So the trustee LLC is not going to have an EIN automatically assigned to it. It's not going to have a bank account. It's not doing any business. The holding company very much is doing business. All of your rental LLCs are owned by the holding company. All of the money is flowing up to the holding company. It has a bank account, is doing transactions. But from a legal, like how to set one up standpoint, it's still just an LLC located or registered in Wyoming.
Okay. Can a trust purchase property?
Sure. We do trust to purchase all the time. It's typically, again, because of the anonymity and banking issues, typically all cash purchases. We've had some clients say that their lender is okay with closing in the name of the trust. Often they will see that it's not the client as the trustee, and backpedal from that. In those cases, it's very easy to just close in your name and then transfer the property to the trust and to your structure after the fact. That's how most things happen. But some people, if you have the ability to purchase in cash, or you have a lender who will fund your buy with a trustee LLC or a nominee trustee, then you can close in a land trust. No
But this
reason
is
why
how
you couldn't.
Walt Disney bought half of Orlando, and this is how the mafia bought half of Chicago during the Roaring '20s. Yes, but it's easier if there's cash.
Correct. Cash is
That's
king. You can
okay.
do whatever you want.
Yep. Okay. When a Wyoming trustee LLC is more appropriate to use than a nominee versus a nominee trustee. Okay, you showed both of those options.
Mhm.
And
The
which one's
trustee
more
LLC, you just have more control over the trustee LLC. So we've had situations where the client's like already in the process of selling the property, and they're 3 weeks into and they're closing in a few days, and suddenly whoever was supposed to be looking at the paperwork weeks ago finally looks at it and realizes that Clint Coons is the trustee, not the client. And they're frantically trying to get resignation paperwork from us. Typically, you should already have that in your documents, but maybe you moved, maybe something happened and you can't find them. And they're trying to get some sort of deed signed or something, and Clint's in Hawaii for the executive retreat. Well, sorry, we're not going to be able to get to him. So, but if you have your own Wyoming trustee LLC, you're the manager, you control that, and so you can sign on the dotted line at any point.
So Edgar, my feeling on that is if you're doing a lot of real estate transactions, it might be worth it to have a separate Wyoming holding company, a separate Wyoming trust. If you've got 2 rental properties and that's all you're ever going to have, I think it's overkill. Is that fair?
Yeah,
Okay.
definitely.
Okay. What if the mortgage is the name of the person who wants to be anonymous? Mortgage is sort of a matter of public record.
Yeah, it's in the chain of title. There's not going to be anything you can really do about removing it from the chain of title. The idea is that in an asset search, your name's not on the record. Your tenant isn't looking up, okay, who's on the deed? It's not you. You have to have a little bit more savvy to go back to say, oh, there's this mortgage. Oh, I'm going to make that logical inferential leap to say this person might still be connected to the property. Am I going to hang my hat on a maybe? You could, but not always.
Remember that anonymity is not the ultimate goal. Asset protection is the ultimate goal. The example I've used, and some of you students have heard this, remember when O.J. Simpson sort of killed his wife, but he sort of didn't, but the glove
Allegedly.
didn't fit. Yeah, allegedly. And so, and he had his Florida home, dumped millions of dollars into it. They couldn't touch his NFL pension plan. They couldn't touch his Florida home. He's standing behind bulletproof glass going, neener, neener, neener. What are you going to do about it? That's good asset protection. Anonymity is a tool that can be used to hide assets, to transfer properties, but it's a tool, but it's not the ultimate goal. A land trust is a good anonymity tool that's sometimes very effective at doing what you need to do. Is that add to that, Amanda?
No, I mean, you hit it right on the head, Don. It's a smoke screen. It's not the bulletproof vest. It's designed to confuse. It's designed to distract. It's designed to create enough hurdles that it's not worth it for the person looking for you to keep looking. Okay.
LS is saying, so a land trust won't work in Pennsylvania. No, it will work. We can't find a way to get around those darn transfer taxes in Pennsylvania. So you use a pocket deed or a sleeper deed or a dresser drawer deed, whatever you call it. It's going to sit in your dresser drawer. It's an unrecorded deed that's signed, it's notarized, it's all ready to go. And when we get ready, we transfer the deed in. And they're looking at the date of that it was signed and notarized.
Yeah,
but you don't pay the
effective when
transfer
it's signed.
taxes until you record the deed.
Exactly. Mhm.
So
In Pennsylvania, a lot of times I would say you probably better just to transfer directly to an LLC, since you're not recording the deed. If your idea is to use the land trust for the anonymity and you can't get the anonymity because you can't record the deed without paying the tax, you don't want to pay the tax, then just transfer directly to the LLC, because if your property gets sued, or if you get sued as the current title holder of your property, you walk in with that deed, you walk in with your LLC documents, and the liabilities flowing through your structure, not to you personally.
promised you we would end at the top of the hour.
It's
We've got
okay,
time
I'm
for
having fun.
maybe a couple questions. I'm sorry, we're not going to get to everybody, but please take advantage of the opportunity they're given for a consultation. And on that, we've answered almost 100 questions, and we have 44 still open. I'm sorry we're not going to get to everybody, but we're giving you that opportunity. Kendall, will you put that in the chat screen one more time? Click on the link, sign up for that. Amanda, is there any questions here that you have in the 2 minutes we got left? Anything that you want to tackle?
No, we have covered. I feel like we've covered some things twice. But it is one of those things where it takes a few repetitions to sink in. It really does. And with Anderson, not only do you have access to our amazing attorney team who could all answer any of these questions that we've talked about today, but I'm also actually very proud of this. I've worked really hard to create resources so that your most frequently asked questions are easily accessible. You're not waiting to talk to somebody to find the answer. Almost everything that we've talked about today is on a land trust and deed forum. It's got a pre-recorded video where I go over a lot of the stuff we talked about today. It's got a frequently asked questions section. It's got links to every video Anderson or Clint or Toby or Coffee with Carl having to do with land trusts that we've ever created in the history of time. So we know that it's a misunderstood tool and that there are a lot of questions. So I've really tried to make the answers to those questions very accessible to our clients.
And my closing remarks is, don't do a land trust on your own. I can walk you through how to set up an LLC. I can walk you through the steps to set up a corporation. I can walk you through a deed. There's so many things that are somewhat simple to do. A land trust, because there's so many steps, I would probably not recommend that. Anyway, with that, Amanda, I'm so grateful for your time, for your expertise. There are some great resources with Anderson. Again, and go back and listen to this recording. We've recorded this. We're going to send you the link. You'll get it tomorrow sometime. It'll come from Zoom. So listen to this and go over her presentation, because her slides really did answer most of the questions that you're asking. And so go back and listen to those again. Amanda, thank you for your time. You've been
for having me.
So delightful and fun to have. Students, thank you for being on and being patient. I'm sorry we didn't get to your questions, but we did provide an opportunity for you to get them answered, and we do want them to answer. And so please take it, that opportunity for a consult. Thank you for your time. So very much appreciate you. And a lot of you, maybe most of you, will see you in a couple of weeks at the 3-day summit. Thank you for being here. Good night.